Okay, people, next we are going to study is the negotiation of negotiable instrument. Negotiation of negotiable instrument. What do you mean by negotiation? Negotiation means that you are transferring the negotiable instrument. Okay. So what do you mean by transfer here? It means that when you give that negotiable instrument to some other person to make him the holder of the instrument. Matlab, what is your intention? Your intention is that when you will deliver this instrument to the other person, that person will become the holder of this instrument. Then we will say that you have transferred the instrument. Okay? It is all about your intention. Your intention should be like, I mean, if I am giving the instrument to you, just have a look at it and then return it back to me. That is not transfer. Transfer is that I am giving it to you with an intention that it is yours. You are the holder of the instrument. You can keep it with you. That will become the transfer. Now, what we have to study here is, we have to study that how can we do the transfer. There are two modes of negotiation. We have already studied it, right? It says, in case of promissory note, bill of exchange or check, which is payable to bearer. Bearer means that there is no name written on the instrument. In that case, you can simply deliver it and it will be transferred. Yes or no? Yes. But if the instrument is payable to order, the instrument is payable to order, in that case you have to specify the name of that person to whom you are transferring, and then you should deliver it. It means it can be delivered how? Endorsement plus delivery. Are we clear with this thing? In case the instrument is payable to bearer and you are transferring it by delivery, this delivery can be made in two ways: actual delivery or constructive delivery. What do you mean by actual delivery and what do you mean by constructive delivery, and how it works? Right? It works the same way as delivery works in Sale of Goods Act. Actual and constructive. The thing is, in actual, it will be a direct transfer from one party to the another. Means you are changing the hands. I have the instrument with me, I have to transfer to him, I am giving it to him. Change of the physical possession. Are you clear? This is same thing. Constructive works in a bit different way. How this constructive thing works? Look at this screen, please. There are, let's say, two parties, A and B. There are two parties, A and B, where A has to transfer the instrument to B. Now, if it is a constructive delivery, in that case, the transfer will not be a direct transfer. How this transfer will work? A will give this instrument to C and C will give this instrument to B. Now the point is, sir, who is this C? C could be the agent or could be any person who is authorized to take the delivery of instrument on behalf of B. Are we clear? Yes or no? So this is the direct transfer and this is the indirect transfer. Are you clear on this? Yes or no? Yes. This is negotiation by delivery, what I have explained here, and this is negotiation by endorsement, what I have explained here. Endorsement plus delivery. Are you clear with this thing? Okay, this section number 46, that is importance of delivery in negotiation. You can read it on your own. I'll just tell you what is actually the thing, how the things are working. How important delivery of instrument is when you are transferring it. If you remember, when we were discussing the features of the negotiable instrument, there I told you very specifically that the liability of a person will arise only and only when the instrument is delivered. It means if you make the instrument and you keep it with yourself, right? It means the liability of the other person will not arrive. So you have to take his acceptance, you have to deliver it, you have to give it to the other person. It means the person who is paying should have that instrument with him to claim the payment on the required date and time. Getting a point? So, if you ask me, sir, is it really important to deliver the instruments when you transfer it? 120%. Means if I am making a check in your name to make a payment to you, so when I'm writing the check, your name, amount, date, signature, etc. For you to claim the payment, I should deliver the check to you. If I don't deliver this check to you, there is no chance that you can claim the payment from the check. Getting a point? It means delivery in transfer is very important. It is one of the main element of negotiable instruments. Are you clear? Everybody, yes? This is, I told you constructive delivery, actual and constructive delivery, right? This is what is explained here. When you are transferring it or when you are delivering it, so delivery to be effectual must be made by the party making, accepting or endorsing the instrument or by a person authorized by him in that behalf. Here two things are being explained, this part and this part. What are these two parts? Let me just explain it to you. The question is, sir, who can deliver the instrument? Number one. Second, to whom the instrument can be delivered? What is the first question? Who can deliver the instrument? Second, to whom the instrument should be delivered? Generally, the drawer, the maker of the instrument, or anybody on his behalf who is an authorized person can deliver the instrument to the other person. Yes or no? So, if I am the drawer, I am the maker, either I should deliver the instrument on my own directly, or anybody I will authorize to deliver the instrument on my behalf, he can deliver it. The question is, sir, to whom the instrument can be delivered? As I told you here, there are two types of delivery you can use here, actual and constructive. Up to whom I should deliver the goods? The instrument. To whom I should deliver the instrument? I can deliver the instrument directly to the person for whom I have drawn the bill or any instrument, yes or no? That will be an actual delivery, change of hands, physical delivery, yes or no? And second is, I can deliver the instrument to a third party on his behalf. This party could be his agent. This party could be any authorized person authorized by him to receive the instrument on his behalf. Getting a point? Who can deliver the instrument? The maker, the drawer, or anybody on his behalf who is the authorized person. To whom the instrument should be delivered? To whom the instrument should be delivered? Drawee or payee, or any person on his behalf who is the authorized person or his agent. So that is what they are writing here. Delivery to be effectual. Delivery to be effectual means delivery to be valid must be made by, who should make it? The person who is making it, the person who is making the instrument, or accepting the instrument, or endorsing the instrument. If I am transferring the instrument to you, then who should deliver the instrument? I should deliver the instrument, or any person authorized by him in that behalf. You getting a point? Yes or no? Any doubts, any questions here? 1 minute. Clear है? हाँ. Promissory note, bill of exchange. In case of bill of exchange, I will draw the bill. I will give it to you. You will accept it, and then you will give it back to me only, no? You are the acceptor in bill of exchange. Correct? So when you are accepting it, who is transferring that bill to me? Who is delivering that bill to me? Only you will transfer, no? Or you will only give the bill to me, no? Who are you? Acceptor. Are we clear on this? Yes or no? Yes, sir. To whom it should be delivered? It says it may be shown that instrument was delivered conditionally or for a special purpose only, and not for the purpose of transferring absolutely the property therein. It basically says that if you are making a constructive delivery in this case, what will happen? I am delivering the instrument to him, right? If it is a constructive delivery, in that case, he is not the holder. He is not the final holder. I am not delivering it to him so that he can hold it with him. Rather, he is holder in due course. Now try and understand. Let us say he is the agent of this person. Look at me. He is the agent of this person. I gave an instrument to him stating that I am giving this instrument to you, but it is not your instrument. You have to deliver this instrument to him. In this case, what will happen? I am delivering the instrument to him and he will deliver the instrument to the main person, the holder. Yes or no? So this person who is holding the instrument for some time, that is not to be a holder but to deliver that instrument to the actual holder. This person will be known as holder in due course. Are you clear with the things? Yes or no? Sure? That concept is clear ना? Holder in due course. कुछ प्रॉफिट नहीं है, उसका एजेंट है वो. सर होल्ड का मतलब है आप जोमेटो यूज करते हो, जेप्टो यूज करते हो, ब्लिंकिट यूज करते हो, राइट? अब जोमेटो का जो ओनर है वो खुद को आके डिलीवर नहीं करेगा ना कुछ आपके घर पे, वो तो अपना राइडर भेजेगा ना. यस और नो? ही विल सेंड हिज राइडर. करेक्ट है. सो राइडर कौन है? राइडर इज होल्डिंग योर ऑर्डर not to consume but to deliver it. So he is the holder in due course. Are you clear? Yes or no? Yes. So that is the concept of delivery of the instrument. Correct? Moving on to the next concept, that is a very important concept. Listen to this concept bit carefully. This concept covers a very important part, that is the dishonor of check for insufficiency of funds in the accounts. Before I start this part, understand this thing very carefully. Here two things are mentioned which is to be understood very carefully. First thing, it says that the check is being dishonored. What is the first thing? The check is being dishonored. Ab check may dishonor because of XYZ reason. There could be n reasons for dishonor of check. Sign mismatch, a particular thing is not filled, there is a cutting, this that. Correct? One of the reasons of dishonor of check could be that there was no funds in the bank account. Okay, so here in section 138 to 142 we will study about dishonor of check, but here the reason of dishonor is not anything else but only and only insufficiency of funds. It means if the check is getting dishonored because of any other reason than insufficiency of funds, then these sections will not apply there. Are you understanding a point? If the check will dishonor only because of insufficiency of funds, then and then only these sections will apply. Otherwise, these sections will not apply in that case. Are you clear? Say, if you understand this part, let us start with the dishonor of check for insufficiency etc. of funds in the accounts. Okay, we will do the reading part, but let me just tell you two cases first. Two cases. First case. Let us say Mr. A is writing a check for Mr. B. Correct. The amount of the check is 5 lakhs. What is the amount of the check? 5 lakhs. The check amount will be debited from Mr. A's account. Will debit from Mr. A's account, yes or no? Yes. Correct. Now there could be two cases here. First, the amount of the check is 5 lakhs. In A's account, he is having only 3 lakhs. He is having only 3 lakhs. In this case, what will happen? The check will not, it will not honor. The check will dishonor. Yes or no? Yes. This is insufficiency of funds. Okay, if you read it here, it is very clearly said, where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money for another person from that account, or for the discharge in whole or in part of any debt or other liability, or is returned by the bank unpaid because of these two reasons. First, amount of money standing to the credit of the account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from that account by an agreement made with that bank. First, it says that whatever amount of check has been drawn, that amount is not available in the account. The thing I told you. Correct. Second thing says that Mr. A has instructed his bank, understand this thing carefully please, has instructed this bank that bank should not clear any check over and above 2 lakhs. Without his permission, bank should not clear any check over and above 2 lakhs. Correct? In this case, let us say Mr. A, writes a check of 3 lakhs. Are you clear? In his account, 3 lakh rupees are available. Fund is there. But A has drawn a check which is exceeding the limit which he has set with the bank. Yes or no? In this case also the check will dishonor, and we will say that the check has dishonored because of insufficiency of funds. Although the funds are there. But it is being dishonored because of the check is being dishonored because of the fact that he is exceeding the limit he has set with the bank. This thing also is covered in this part, which is known as the dishonor of check because of insufficiency of the funds. Are we clear? Two things, guys. First, you are writing the amount in the check and that amount is not available in your account. Clear hai? Check will dishonor. Second thing, the amount might be available, but if you are writing a check where you are entering the amount which is exceeding the limit you have set with the bank, then also bank will say that the check has been dishonored because of insufficiency of the funds. Are we clear? Sub reason will be that the limit is exceeding. Bank will say sub reason the limit is exceeding as set by the account holder. Are we clear, guys? Sure. Acha, when this will happen? Doubt again? Boliye. It is not about that he knows that I have 2 lakh or 3 lakh. It could be by mistake also. It could be a fact that the check has been given today, right? And the limit was set yesterday. Now this person is presenting the check now. So this limit will exceed, no, automatically. So in any of these cases where the account holder sets the limit and any person presents a check from his account which is exceeding that limit, bank will not clear it. Sorry. वो भी हो सकता है. That can also happen. If it is about the permission, bank can take permission from Mr. A and then can honor the check. Sometimes what type of instructions account holder will give, that you should not clear any check over and above this account. वहाँ permission की बात ही नहीं होती. I can refer one case with you people. You remember in Companies Act when you were studying the principles of constructive notice and what do you call that, indoor management, right? In that case you might have read one Turkwan rule, Royal British Bank और Turkwan का same case हुआ था वहाँ पर भी. The limit was changed by the company but was not informed by to the bank. समझ रहे ना? तो sometimes what happens that you set a limit with the bank, right? And you say whatever happens, you should not clear any check over and above this account, over and above this amount particularly. So bank will not clear it. If you say specifically mentions that you can take the permission before honoring the check, then bank will not dishonor directly. Bank will ask you, shall I honor this check? If you say no, bank will not honor this check. Simple dishonor हो जाएगा. Are you getting a point?
But first case, the overdraft facility won't work.
Overdraft will work. It will be included here. If you are writing any amount over and above the overdraft, that will also be dishonored. Let's say the amount in your account is 5 lakhs and the OD facility is 50%. It means you can write any check over and above, within the amount of 7.5 lakhs. So if you are writing a check of 8 lakhs, let us say, the check will dishonor because that is exceeding not only the amount in your account but also including the OD limit. हाँ? Sir, full check will dishonor. ऐसे excess amount dishonor नहीं होता है. Full check will dishonor. You have to write exactly that amount only what you can withdraw from your account. It is not that 7.5 lakh was your limit and you are writing 8 lakhs and 7.5 lakh the bank will clear and 50,000 will be dishonored. ऐसा नहीं होता. Full check amount will get dishonored. Are you clear? Yes or no? Guys, if this dishonor is happening, if this dishonor happens, in that case there are two types of punishments. Okay, first is the fine and second is the imprisonment. In case of dishonor of check because of insufficiency of the funds in the account, in that case the fine could be up to double the amount of the check. Whatever amount of check is there, up to double the amount of the check could be the fine. And what could be the imprisonment? Up to 2 years could be the imprisonment. देखिए, it is clearly written that any person whose check is being dishonored here, such person shall be deemed to have committed an offence and shall be punished with imprisonment for a term which may extend to 2 years. Extend to 2 years means up to 2 years. Acha, that does not mean that if your check is getting dishonored for the first time and in the first time only you will be thrown in jail. ऐसा नहीं होता है. It is like such people are thrown in jail whose checks are getting dishonored very repeatedly. Are you clear? So imprisonment is up to 2 years. Up to 2 years means don't try 2 years directly. There's a difference between up to 2 years and 2 years. Up to 2 years means it could be 1 day also. It could be 1 day also. It could be 2 months also, 2 days also. Right? Maximum will be 2 years. Or with fine which may extend to twice the amount of the check or with both. Right? Fine which may extend to, as I told you, the fine could be up to twice the amount, up to 2 times, and the punishment is up to 2 years. Are we clear? It simply signifies one very important part. One second. It simply says one very important part, that higher the amount of check which is getting dishonored, higher chances that you have to pay the penalty fine as well as you have to go to imprison. Lower the, वैसे तो it is like lower amount of check also can fetch the fine. Lower amount of check can also fetch the fine. I'm just telling you that if the amount of check is higher, in that case what will happen? Your fine will increase. And there is no upper circuit here. Try and understand. There is no upper limit. It is saying up to twice the amount. It means if the amount of check is 1000 crores, for example, the fine could go up to 2000 crores. Are you getting a point? So it is up to twice the amount and up to 2 years ka imprisonment. Sir. So that is what I was explaining. Extend to 2 years means minimum will be 1 day. It could be 1 hour also. Maximum is 2 years. When you say extend to, up to, that becomes the maximum limit. Are you clear on this? Guys, understand one thing very carefully here. Now the point is, sir, this fine and this imprisonment, when it will apply? देखिए, it does not happen like this that today your check is dishonored, tomorrow you are going to court and next day you have to pay the fine or you have to go to jail. ऐसा नहीं होता है. There is a process for that. Look at me, understand the process carefully and then we will move in. Are we clear? The process I am explaining is explained here only. We'll do the reading afterwards. I'll just tell you like that only first. सुनिए ध्यान से. Let's say I give you a check today, amount of check 5 lakhs. You presented the check and the check gets dishonored because of insufficiency of the funds. Right? In this case, what will happen? The check will get returned to you. I mean, the bank will deliver the check to you that your check has been dishonored. You will receive a full pura explanation that why the check was dishonored. Reason will be mentioned. Insufficiency of funds. In that case, 138 to 142 will apply here. Now what will happen? When you get a check, when you get the information of the dishonor of check, directly you cannot go to court of law and file a suit against me. What you will do is, you will contact me that, sir, you gave a check to me and the check has been dishonored. Just now I got to know from the bank. From your information, right? How many days you have to inform me about dishonor? 30 days. How many days? 30 days. So you will have, let's say today you get the information about dishonor of check. From today, you have to inform me first within how much time? 30 days. Correct. Okay? The moment you will inform me, From that day, I will have 15 more days to make the payment to you. For example, today, let us take the dates. Let us say 1st of April 24, you get the information that the check has been dishonored. So from this date, within 30 days, you should inform the account holder that your check has been dishonored. Okay? Whenever you will inform the account holder from the date of information, from this date, account holder will have next 15 more days to make the payment to you. Are we clear? Like 1st April 24, you got the information, so check has been dishonored. Count 30 days from here. 30 days will be 31st of March. My bad. Sorry. 30th of 30th of April 24. It means it is your duty to inform me within this date that your check has been dishonored. Let us say you inform me on 30th of April. May, sorry, right? 1st April to, sorry, 30th of April, right? In fact, it will be 1st of May, whatever it is. So let us say 30th of April, you have to inform me that your check has been dishonored, correct? Post which I will have 15 more days, that is till 15th of May 24, I can make the payment to you. If you inform me within the time and I don't make payment within these 15 days, then you can go and file a case against me stating that the check was dishonored. I informed him on time and he didn't make the payment within 15 days of the information. After this, these fine of up to twice the amount and imprisonment of up to 2 years will apply there. Are you clear? So simply speaking, total of 45 days you have to wait before you file complaint against the account holder. 30 days for this information and 15 days for the payment. Are you clear? Yes or no?
Yes, sir. Sir, if he informed me 15 April, I'm from 15 April.
Your answer is here. It is clearly stated that the information should be given within 30 days. If you delay, it is on your part.
I'm not talking about delay. Earlier,
So if you're not taking full 30 days, in that case, this is the maximum limit. Let us say today you got the information of dishonor and tomorrow you inform me.
What about 15 more days?
Sir, 1 second. Let me complete. Today you got the information and then you inform me tomorrow that say your check has been dishonored. So from tomorrow my 15 days will start. 30 days is the maximum time for you to inform me. If you are not consuming full 30 days, you are informing me within that time. So whenever you are informing me from that time, my 15 days will start. 45 days is the maximum limit. Are we clear? 45 days is the maximum limit. Getting it?
Yes, yes.
You can read this section now. 138 will not apply unless the below conditions are complied with. It means you have to fulfill these two conditions and then only the 138 will apply. Read it. Check presented within validity period. What is the validity period? बेटा देखिए, I showed you a check yesterday. You write date here. Whatever date you mentioned here, from this date till 3 months, the check is valid. Post 3 months, the check will become stale. It cannot be used. So very first thing is the dishonor will be taken into this account for section number 138 only when first condition says that you must have presented that check for payment within validity period, that is within 3 months of the date mentioned on the check. Are we clear? Read it. The check has been presented to the bank within a period of 3 months from the date on which it is drawn or within the period of its validity, whichever is earlier. Are you clear with the first point? Second says, demand for the payment through the notice. Demand for the payment of check through a notice. Demand means that whenever you get to know that the check has been dishonored within 30 days, of the receipt of information by him from the bank regarding the return of check as unpaid. Means you have to inform the account holder within how much time? Within 30 days from the date you have received the check from the bank which is unpaid. Okay, post which failure of drawer to make the payment. What is by failure of drawer to make the payment? It means whenever you have informed him within 15 days of the receipt of the said notice, whatever this notice is talking about, within 30 days the notice should be given. Whenever drawer has received the notice from the person to whom you have to make the payment, from the payee, okay, from that date within 15 days you have to make the payment. So it means if the check is not presented within the validity period, 138 will not apply. If you have not given the notice of unpaid check within 30 days, 138 will not apply. If I have, I have paid the amount within 15 days, in that case, this 138 will not apply. If I don't pay within 15 days, if I don't pay the amount, in that case, that fine and imprisonment will apply upon me. Are we clear? 3 conditions are there. Presentment of check within the validity period, number 1. Number 2, बोलिए ना. Number 2 is demand notice within 30 days. These 30 days will start from which date? When you get to know about the unpaid check. Third thing is that you have to give me how much time? 15 days. It means whenever you give this notice to me that your check has been dishonored, from that date I will have 15 days to make the payment. If I don't do that, in that case 138 will apply. Are we clear? And remember one thing, there is an and between these 3 conditions, it is not or. And means all the 3 conditions should be satisfied together. Are we clear? Read this example quickly. As I told you people one thing, total of 45 days after 45 days of dishonor of check, then only you can basically file a case against the person. You have to wait for 45 days. Read this example number 16 very carefully. Sir, I gave you a check for whatever date. From that date within 3 months, you should present the check in the bank. Okay. Second thing, check is dishonored. How will you get to know about it? Bank will inform you. So from the date when bank has informed you, your 30 days will start. Within those 30 days, you will inform me. Whenever you will inform me, whenever, from that date, my 15 days will start. Total हो गया 45 days. Maximum limit 30 days for you, maximum limit 15 days for me. Are we clear? Remember one thing, it is specified in this example also. The validity period of 3 months will not start from the date on which you have written it. Will start from the date on which you have entered or you have written on the check. Are we clear? Yes or no? Penalty, I hope everybody is clear with the penalty part also. Penalty, it says according to section 138, the dishonor of check is a criminal offence and is punishable with an imprisonment of up to 2 years or fine up to the twice of amount of the check or both. Right? One more thing, listen to me carefully. Sometimes what will happen? Sometimes court will say you have to pay a fine also and you have to go to jail also. That person might say that, sir, I don't have money to pay the fine. Now what will happen? It is not about double dual, nothing like that. It is simply like court will extend his term of jail. The jail ka term will be extended. Ab how much extension will be given, that court will decide. Are you clear? That huh? It is up to court. Generally, it will not be up more than 2 years. It will be within 2 years. Sometimes the order sanctioned by the court is that 2 years imprisonment will be, you have to suffer 2 years of imprisonment. Plus whatever check amount is there, fine, you have to pay the fine also. Sir, I don't have money to pay the fine. What will happen? Court might extend your term of jail. It could be beyond 2 years also. It depends upon case to case basically. सर वो अरेंजमेंट आपका और कोर्ट का इंस्टॉलमेंट का इसमें कहीं नहीं लिखा हुआ. इट इज सिंपली लाइक, बोलिए.
मतलब मैंने चेक इशू किया था, पीडीसी है, उसके बाद फिर मैंने कोर्ट से वो ऑर्डर ले लिया मैं इंस्टॉलमेंट में कुछ दिन बाद. उसके बाद उसने चेक डाला बैंक में.
उसमें कुछ नहीं होगा सर. आप यू आर सेइंग दैट यू हैव गिवन पीडीसीज टू सम पर्सन. लेट्स से यू हैव फाइनेंस्ड अ कार and you have given PDCs, 6 PDCs to make the installment ka payment, correct? And today you give the checks, and next month you have declared yourself insolvent. And what court is doing now? Court has appointed an official receiver, and he is investigating your case. And meantime, the checks are dishonored. Anyways, when you will apply for the insolvency, this official receiver will inform your bank also that this person has applied for insolvency, and in case of any checks which are presented for the payment, anyways those checks will be dishonored. So bank should inform the receiver that this is the person who is the creditor of this person. So that receiver will enter his name, the bank name, in the list of the creditors of your case. And when your assets will be accumulated and sold, money will be realized. That money, if it is sufficient enough to comply all your liabilities, in that case it will be set off. If it is like your assets are worth rupees 10 lakhs but your liabilities are 1 crore, in that case this amount will be divided between all the creditors in pro rata basis, like what we call in the proportional basis. That is what it happens. So yeah, that's clear, right? Done? Any doubts here? This topic is over. We are moving to the next topic, that is presumption in favor of holder. If you remember in the starting, I told you that in this chapter we are going to study these 4 topics. Yeah, I told you 4 topics. This is the third topic of rules, post which we are going to study the rules of compensation, the solution, the remedy. Clear? Shall we start? देखिए, it says when a check is dishonored, it shall be presumed, unless the contrary is proved, that the holder of a check received the check of the nature referred to in section 138 for the discharge in whole or in part or any debt or other liability. Presumption prescribed here is a rebuttable presumption, as the provisions clearly provides that the person issuing the check is at the liberty to prove that the contrary. The effect of this presumption is to place evidential burden on the accused. I'll just sum it up in easy language. It talks about onus of proving. Onus means burden. Onus का क्या मतलब होता है? Burden. For example, अभी you leave this case. छोड़ इस केस को छोड़ दीजिए. If I file a case against you that you assaulted me, for example, I am saying you have assaulted me, who will prove that the assault was there? Assault happened. You will prove or I should prove? I will prove. It means the burden of proving it is on me. Correct? Similarly, when I am giving check to you, in that case, if the check is dishonored, dishonor of check is a criminal offense? Yes or no? Yes. In that case, if I want to save my life, in this case, I have to prove that the check I gave to you was with a bona fide intention. It was just misrepresentation, it was not fraud. It was just a misrepresentation, it was not fraud. It means I didn't give a check to you with a mala fide intention. My intentions were good. Okay? I actually didn't had the knowledge that that there is no amount in my account. If I would have known that the amount is insufficient, I would have deposited the amount so that your check could be cleared. It is me who has to prove it. You will not prove it. Are you clear? That is what it is saying. The effect of this presumption is to place evidential burden on the accused. Who is the accused person? I am the accused person. The drawer, correct. You are accusing me. Up, if I've given check to you, you are going to court. Sir, fraud kara hai. He has committed a fraud. Then I will only prove, no, sir, I am very innocent. This is the wrong allegation, right? I didn't had any idea, or I really forgot that I have set a limit with the bank, or I really don't have any idea that there is insufficient account funds in my account. Otherwise, I would have revoked the limit, or I would have deposited additional amount in my account so that this check could be cleared. So it means I am working with a very bona fide intention. So if I can prove this, that I was working with a bona fide intention, then देखिए fine तो I have to pay. Imprisonment, if court orders, I have to go, whether I was working with bona fide intention or I was working with malafide intention. Then sir, if it is like this, then why are you proving that you are bona fide? To reduce the effect of the punishment on me. Are you getting a point? देखिए in law, it is a very simple thing. If it is your mistake, if you have committed a mistake unknowingly, it hardly matters. You cannot save yourself by simply saying that, sir, it was a mistake. Or, as you have said in Indian Contract Act, ignorance of law is not an excuse. You didn't knew the law, right? Or it was violated by mistake. You cannot save it. So, why we are studying this thing? Why the accused is proving? Just to reduce the burden of the punishment on him. Are we clear? Yes or no? Sure, yeah? Guys done? Huh? It is not so easy to prove your intention, because your intention, it is like only you know the intention. Nobody else apart from you know the intention. How can you prove that you are not thinking wrong about me right now? Batao. Can you prove it? No. Are you getting a point, guys? It says it shall not be deemed a defense in the prosecution of an offence under section 138 that the drawer had no reason to believe when he issued the check that the check may be dishonored, or presentment of the reasons stated in that section. It means it is simply that is what I said. Ki if I prove that, sir, I didn't had any idea about the insufficiency of funds, I really forgot about the limit I have imposed on the check amount with the bank. Otherwise, I would have not given the check to him. That will not save me from bearing the punishment. Punishment to hoga hi hoga. Punishment to I have to bear the punishment. As I told you, I am not proving my intention to get away from the punishment. I am proving my intention just to reduce the burden of punishment. That is what they are writing here. Are you clear? Guys, that was about the dishonor of check. Clear hai? देखिए, next we are moving towards the rules of presenting the instrument. Presentment of instrument. First says presentment for acceptance. What do you mean by presentment for acceptance? It means you are presenting the instrument to the other person so that he can accept it. Bill of exchange you gave for the acceptance. Promissory note you gave for the acceptance. Are you clear? So if you are presenting the instrument for acceptance, in that case, what all rules will apply? Let us read very carefully. It is a bill of exchange payable after sight must, if no time or place is specified therein for presentment, be presented to the drawee therefore for acceptance, if he can, after reasonable search be found, be a person entitled to demand acceptance within a reasonable time after it is drawn and in business hours on a business day. इसको sum up कर देता हूँ. I'll just sum it up for you. If you are the person to whom I have to give the bill of exchange or any other instrument for the acceptance. I should give it to you for the acceptance on any business day within the business hours. Working day, working hours. Okay, working day as in
Sunday, Monday. Sunday, Saturday, Sunday.
Monday to Friday. Business days, business hours 9 to 6, 9 to 5, 9 to 6. Are you clear? Yes or no? In default of such presentment, no party thereto is liable thereon for the to the person making such default, if the drawing cannot, after reasonable search, be found the bill is dishonored. Very simple thing. You have to first find the person who shall accept the instrument for you, present the instrument to him, that within the working day, within the working hours. And if you cannot find the person who should who should accept the instrument for you, in that case, that particular thing is assumed to be dishonored. It means the payment will not be cleared, or that will not become the valid instrument. Right? As we have already said in the features of the negotiable instrument, that the instrument has to be accepted to make it valid. Clear है इतना? हाँ.
Sir, Saturday को भी तो business hours होता है, मतलब 9 to 1 half day.
सर आप बैंक में थोड़ा ना काम कर रहे हो यहाँ पे कि 9 to 4, 9 to 2 आप हाफ डे कर देंगे.
मतलब half day.
ऐसा कुछ नहीं है सर. मंडे टू फ्राइडे बिजनेसेस रहते हैं. वीकेंड बंद होता है. वीकेंड, नेशनल हॉलीडेज, पब्लिक हॉलीडेज सब बंद रहेगा. बात समझ में आ रही है आपको? क्या चीज़? One more thing, I would suggest here to you people to understand this thing. Sometimes you don't present the instrument physically. Sometimes you send the instrument through a courier. When you are sending the instrument for the acceptance through a courier, remember this thing, that you should opt for a courier which is a registered post, that is the post office. And if you are opting for a private courier, then you should have a POD. POD is proof of delivery. Sometimes you might have seen that if a courier person has came to give you a courier, they will ask you to sign on a sheet. Sometimes you don't ask, sometimes they ask, yes or no. Right? So when you are signing on that sheet is the proof of delivery that you have accepted the parcel. Right? And if you don't want to get into that thing, simply use Indian Postal Services. So use the speed post and you can deliver the thing. Speed post anyways is a government parcel system, so it will be proof that it was delivered. What I am trying to say is, you should use a way where the other person cannot get a chance to say, you didn't send the instrument to me, how will I accept it? You should have a proof that yes, the instrument was sent. Are you clear? That is what they are writing here. Where authorized by agreement or usage, the presentment through the post office by means of a registered letter is sufficient. Are you clear? With the speed post, you can send the instrument. Generally, which method you will opt? Physical transfer or the registered post? By default is the physical transfer, but if you have agreed that you will give it to the other person through a registered post, then you can use the registered post. Clear है ना? Presentment of promissory note for site. It says the promissory note payable at a certain period after site must be presented to the maker thereof for site by a person entitled to demand payment within a reasonable time after it is made in business hours on a business day. In default of such presentment, no party thereto is liable thereon to the person making such default. Before site, after site. These are two concepts which you should understand. After site means what? After site means the business time, like the time for payment I'm talking about. The time for payment will start once that instrument comes into my knowledge. Are you getting a point? It means if I have given an instrument to you, promissory note, that on so and so date I will make the payment to you. That date is today. The due date is today itself. Okay, so I will not make the payment unless until you approach me that sir, this is the instrument you have promised. It means you are showing that instrument to me. The moment I see it, then I will make the payment. So it means you have to demand the payment. I will not make the payment on my own. That is what is the meaning of after sight. Clear it now? Yes or no? Then it says draw's time for deliberation. It says the holder must, if so required by the draw of a bill of exchange, present it to him for acceptance, allow the draw 48 hours exclusive of public holidays to consider whether he will accept it or not. देखिए, when you give an instrument to the other person, you have to give some time to the other person to think whether he should accept it or not. In case of bill of exchange, this time is 48 hours. Are we clear? Presentment for the payment. Guys, look at the screen, please. It says promissory notes, bill of exchange, and checks must be presented for the payment to the maker, acceptor, or drawee thereof, respectively, by or on behalf of the holder, as hereinafter provided. In default of such presentment, the other parties thereto are not liable thereon to such holder. Whether authorized by agreement or usage, a presentment through the post office by means of a registered board letter is sufficient. My point is that when you are presenting the instrument for payment, it is clearly written that these instruments must be presented for the payment to the maker, acceptor, or drawee. I told you, right? The instrument should be delivered. To whom you are delivering the instrument? The person who has accepted it. Yes or no? Who is the acceptor? Yes or no, beta? Correct? Now, who will make the payment? The acceptor only will make the payment. Yes or no? So, when you will present the instrument for the payment, to whom you will accept, to whom you will present the instrument for payment? You will present the instrument for the payment to the person who has accepted it, who has to make the payment. Yes or no? If he is the acceptor of the bill, I cannot present that bill to him for the payment. Right? This is what is saying. The person who is liable to make the payment, the instrument should be presented to him only, so that he can get the knowledge of the instrument and he can make the payment. Are we clear? If you are presenting the instrument to someone else, then it is not his fault, it is your fault. Clear it now? Read the exception quickly. Let us read it together. Exception says, where a promissory note is payable on demand and is not payable at a specified place, no presentment is necessary in order to charge the maker thereof. It means if the promissory note is payable on demand means that whenever you will ask for the payment, you have to make the payment. In that case, you need not wait for the maturity date. You need not present it on the maturity date. You can present it before also. That is one thing. Are we clear? Yes or no? Sure?
डिमांड में जब होता है तो उसकी मैच्योरिटी डेट क्या होता है?
क्या चीज?
सर डिमांड इंस्ट्रूमेंट में आता है तो उसकी मैच्योरिटी डेट क्या होता है?
Whenever the instrument is made payable on demand, right? For example, when you are taking a loan from the bank, the loan is actually payable on demand. Whenever bank, in that agreement what you sign, the loan agreement, it is clearly written that whenever bank will demand, if there is a situation where bank is demanding the amount of loan before the tenure, bank may demand the payment. It is payable on demand. Okay, payable on demand does not mean that it will not have a maturity date. You will specify a particular date. Generally, how the thing works, custom of trade says you will give a maximum date, that by this date you will make the payment, and you will agree that within this time, whenever you want to demand the payment, you may demand so. You can do it reverse also. You can say that till this date I cannot make the payment. Post this date, you can demand the money whenever you want to demand it. So date will be mentioned. Either it is the minimum period or it is the maximum period. Are you clear? बात समझ में आ रही है? Yes or no? The date will be there, so that both the parties have a clarity. You are forgetting the main essence of this act. If you remember, starting only I told you that this act was passed to control the credit trade. Yes or no? So that both the parties should have a transparency. So you have to give the transparency. Payable on demand does not mean that after 10 years you will come and demand the payment. Or today I'm writing and tomorrow you will demand the payment from me. ऐसा नहीं होता. Time is specified there. Are you clear? Yes or no? It says, notwithstanding anything contained in section 6, where an electronic image of a truncated check is presented for payment, the dry bank is entitled to demand any further information regarding the truncated check from the bank holding the truncated check in case of any reasonable suspicion about the genuineness of the apparent tenure of instrument, and if the suspicion is that of any fraud, forgery, tampering or destruction of the instrument, it is entitled to further demand the presentment of the truncated check itself for verification. If you remember, I've discussed the truncated check of working with you people. I told you I will give a check to you, you will present that check with your bank will scan that check and will send the scanned copy of the check to my bank for the clearance of payment. Now let's say my bank receives the scanned copy and my bank gets into a suspicion. I think something is wrong. I don't think that is genuine. I think it is tampered. Tampered means something is, you have changed something. Sign is not good. It is not matching my system. In that case, my bank will have all due rights to demand any information from your bank or from the account holder before clearing the check. Right? Like, for example, my bank can ask your bank, can you please send me the physical copy of the truncated check once? So that I just want to check the genuineness of the check, whether it is correct or not. My bank can contact me, sir, I have received a check that you have drawn on so and so name. Is it you who has drawn this check? If I say yes, bank will clear it. Are you getting it? Yes or no? So that is what is written here. Then it says, provided that the truncated check so demanded by the drawing bank shall be retained by it if the payment is made accordingly. This may happen if my bank is asking your bank to give the physical copy of the truncated check. After making the payment, that physical copy of the check can be kept with my bank, can be kept by my bank in its possession. It means my bank may not return that physical copy to your bank. That can happen. Reason being, my bank is keeping that check for a proof that this is what I have checked all the things and this is the check with me. This is the proof that I have checked it. Are you clear? So this may happen. Are you clear?
Yes,
Sir, your question and uska answer. Presentment for payment must be made within the usual hours of business. And if it is a bank, within banking hours. Banking hours और business hours में difference होता है. When you go for the banking services, you work with the banking hours. And when you deal with the general business services, you deal with the business hours. Are you clear? Yes or no? Banking hour में you will take Saturday का half day, whatever you were saying. Guys, I want you people to read these three sections very quickly. 66, 67 and 68. Make it quick. Guys, section number 66 says, presentment for payment of instrument payable after date or after sight. It says a promissory note or bill of exchange made payable at specified period after date or sight thereof must be presented for the payment at maturity. Means whenever it is accepted, if a instrument is made after date or after sight, it means whenever after sight or after date means what? We're talking about maturity date here. It means if there is a maturity date for a instrument, then you can claim money for that instrument only after that maturity date, not before that. Are you clear? Unless until it is payable on demand. Simple speaking, if I'm writing tomorrow's date, right, that is the maturity date, you cannot demand payment from me today. That is after tomorrow or after that you can demand the payment. That is what it is saying basically. Something which is very obvious here, right? It says presentment for payment of promissory note payable by installments. You understand what are installments, right? Sometimes promissory note is made in a way where you are writing the installments that on this date I will make the payment of this amount, this date this amount, this date this amount. Okay, in that case, what will happen? A promissory note payable by installment must be presented for payment on the third day after the date fixed for payment of each installment, and non-payment of such presentment has the same effect as non-payment of a note at maturity. 3 days का grace period. If I have promised to make the payment in installment, I told you that for first installment I'll pay it today. Then for first installment, whenever you want to collect the installment, right, when will you present for the collection? This day plus 3 days. Whenever the date was fixed, within 3 days you can ask for the payment. Are we clear? Yes or no? General rule says whenever it is installment, before 24 to 48 hours of presenting the installment, you should inform the person that I am going to present the installment. You have to remind that person. Then you will present the things for the installment. Are we clear? Presentment for payment of instrument payable at a specified place and not elsewhere. It says a promissory note, bill of exchange or a check made, drawn or accepted payable at a specified place and not elsewhere must, in order to charge any party thereto, be presented for payment at that place only. If I am saying the payment will be made in Delhi, payment will be made in Delhi only. If I am saying payment will be made in Bangalore, it will be paid in Bangalore only. So when the specified place is mentioned, the payment will be paid on that specified place only. Guys, instrument payable at specified place, सेम थिंग, सेम है, इसमें कोई डिफरेंस नहीं है. इसमें इसके बारे में बात करते हैं. प्रेजेंटमेंट वेयर नो एक्सक्लूसिव प्लेस इज स्पेसिफाइड. देखिए, व्हेन द प्लेस इज स्पेसिफाइड दैट वी अंडरस्टैंड दैट वी शुड मेक द पेमेंट in that place only. But what if the place is not specified? In that case, the promissory note or bill of exchange not made payable as mentioned in the section 68 and 69 must be present for the payment at the place of business, if any, or at the usual residence of the maker, drawee or acceptor thereof, as the case may be. If any office address is given of the maker, you will go to his office. That is the primary thing. Right? If there is no official address given, then you can knock at his door, at his residence door. Sir, today is the payment date. If you can please make the payment. Getting a point? If there is no specified place given, then first you go to the office if the official address is given. If it is not given, then you can knock on the door at his residence, where is given. Are we clear? Try not to approach outside the business hours. Try not to approach outside the business hours or on a public holiday or on any day which is not a working day. Don't go on that day, please. Are you clear? What I'm trying to say, claim payment on working day within the business hours. Okay? Presentment when maker etc. has no known place of business or residence. देखिए, that the above section will apply when you know any one of the address, either the official address or the home address. What if none of the address is not known? It says if the maker, drawee or acceptor of a negotiable instrument has no knowledge, known place of business or fixed residence, and no place is specified in the instrument for the presentment for the acceptance or payment, such presentment may be made to him in person wherever he can be found. It means you have to ask him, where will you be available? Not at your office, no problem. Not at your residence, no problem. Where will you be available? Wherever he is available, you have to approach and you can demand the payment if the place is not specified. Are we clear? Simply speaking, specified place hai, go to that specified place. Place not specified, office. No office, at residence. No office, no residence, then ask him, where will you be available? Are you clear? Yes or no? Next is presentment of check to charge drawer. Subject to the provisions of section 84, a check must, in order to charge a drawer, be presented at the bank upon which it is drawn before the relation between the drawer and his banker has been altered to the prejudice of the drawer. A very important and a very obvious one. It says, if I have given a check to you, correct? Where will you present that check for the payment? Obviously to my bank. Yes or no? To my bank. Acha, if let's say the last part says before the relationship between drawer and the bank are altered. What do you mean by this thing? It means, let us say I decide to close my account with HDFC Bank and I have given a check to you of that account only. It means you should present the check before I close my account. It means my and banker relation comes to an end. Before that only you should present the check. Are you clear on this? Yes or no? Correct? If you present the check after the account is closed, then obviously the payment will not be cleared. Sir, in that case, how will I receive the payment? Then you have to contact me. In that case, I might give you another check, or I might be paying you in cash or maybe in any other form. Are you clear? Yes or no? Sure? Hai? Sir, how the other person will get to know that your relation or you are closing your account? Generally, it is my duty to inform you that I am closing my account. I have given a check to you, so if you can please present your check. After the information also, if you are not presenting the check, it is your fault, not mine. Got my point? Yes or no? Presentment of check to charge any other person. A check must, in order to charge any other person except the drawer, be presented within a reasonable time after delivery thereof by such person. It's a very simple thing. Very simple thing. This and these two sections are really very same. They are saying that if you really want to get your payment, do it within this specified time. Validity period pada tha na? 3 months. So do it within that time. Got my point? If you don't do it within that time, then in that case you are losing your bargaining power. Clear hai? 74 says presentment of instrument payable on demand. I hope all of you understand this thing. What is payable on demand? That you have to demand the payment. Correct? So, if the instrument is payable on demand, it must be presented for payment within a reasonable time after it is received by the holder. Sir, reasonable time. Are you connecting with the point now? Reasonable time means what? No. Reasonable time means that after how many days you will present it for the payment. You cannot wait for 100 years and after 100 years you are presenting your payment. Your grandchild is presenting that check or instrument to the person ki haan, payment lena hai. There is a time, there is a reasonable time, limitation to it. There is a limitation on the times also. Are you clear? To make this thing easy, we put a date. That is what I was telling you. Okay? Otherwise, who will decide what is the reasonable time? Who will decide what is the reasonable time? Court. It is not about the circumstances, it is about the last decision is at the disposal of the court will decide that what is the reasonable time, reasonable amount, reasonable place. Got it? Presentment by or to agent representative of a deceased or assignee of insolvent. Assignee of insolvent means now who is presenting the check? Presentment is done by or to agent representative of deceased. Deceased means the person who has died, or assignee of the insolvent. So, presentment for acceptance or payment may be made to the duly authorized agent of the drawing maker or acceptor as the case may be, or where the drawing maker or acceptor has died to his legal representative, or where he has been declared an insolvent to his assignee. I have a bill of exchange and I want you to accept it, or let's say I want Mr. X to accept it. Mr. X, two cases we are taking. Mr. X is dead or Mr. X is alive but he has declared himself insolvent. If he is dead, then to whom I should approach for this bill? Who will accept it? Who will accept this bill on behalf of Mr. X? He is legal here, yes or no? If he is dead. So if he is not dead, then he is declared insolvent, then I should approach his legal assignee. Assignee means the official receiver who has been appointed by the court of law on his behalf. Are you clear? It works both the ways. If I want the person to accept it, then I should approach legal here or the assignee for the acceptance. And if I have to take payment, then for that payment also I should approach legal heir or official assignment. Clear hai? Clear hai, sir? Right? Everybody here? Sure? Excuse for delay in presentment for acceptance or payment. It says delay in presentment for acceptance or payment is excused if the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct or negligence. When the cause of the delay ceases to operate, presentment must be made within a reasonable time. You did not presented the check or promissory note or anything on time. अब since you have not presented the instrument on time, that does not mean that you will not receive the payment. ऐसा नहीं होता. You can prove. You will always get an opportunity of being heard. You should prove that, sir, why there was a delay. If the delay was caused because of a valid reason, which was beyond your control, then that delay might be excused. They may allow you that thing. But if the delay was because of your negligence, then there might be a problem. Clear है ना? Yes or no? It works same as voidable contract. I hope you can relate with it now. When presentment is unnecessary, it says no presentment for the payment is necessary and the instrument is dishonored at the due date for presentment if any of the following cases happens. If any of these cases happens, in that case, you would say presenting the instrument is not necessary. Correct? It is unnecessary. What are the points? First point is if the maker, drawer, acceptor intentionally prevents the presentment of the instrument. If I am intentionally doing something through which I am trying to avoid the presentment, it means, do you remember attempted performance? You बोल रहा है. If you try to present the instrument, but the maker is avoiding the presentment, in that case, don't worry, you are safe. He is avoiding, it means you have attempted your performance, it is at his point now. Are you clear? You can claim money from him. Correct? If the instrument being payable at his place of business, he closes such place on a business day during the usual business hours. It means the address of his office is written there, that at this place I will make the payment, and the date on which you have to receive the payment, that office is closed during the business hours. In that case, you are not at fault. It is him who is at the fault. Are you clear? It is not your problem. It is his problem. So you can go to him next day. In that case, he will not be able to say that, sir, yesterday was the date, no, why you are coming today? Willful default. I'll be clear? If the instrument being payable at some other specified place, neither he nor any person authorized to pay it attends at such place during the usual business hours. There was no specified place, or there was some place which was specified. You went there for the payment and nobody is entertaining you. Nobody is talking to you. Nobody is asking you what to do, what not to do. In that case, you went to that place during the business hours, your job is done. Are you clear? If that person who has to make the payment or any of his agent was not there, it is not your problem, it is his problem. Got it? If the instrument being payable at a specified place, he cannot after due search be found. Place was specified, you went there and you cannot find anybody here. Or that place is not existing. In that case, your problem is like you are not at the default part, it is his default. Are you clear? As against any party sought to be charged therewith, if he has engaged to pay notwithstanding non-presentment. Read this point, try to understand this point once, I will explain it to you. पढ़िए क्या बोल रहा है? Try to get the language. As against any party sought to be charged therewith, if he has engaged to pay notwithstanding non-presentment. बोलिए. ज़्यादा डिफिकल्ट है. सुनिए, कह रहा है एज अगेंस्ट एनी पार्टी सॉट टू बी चार्ज्ड means any party has to make the payment to you and that party agrees, need not present the instrument, I will make the payment to you, I know that I have to make the payment to you. So without you presenting the instrument, the other party is ready to pay you that amount. In that case, you need not present the instrument. Clear hai? Yes or no? As against any party, if after maturity with knowledge that instrument has not been presented, he makes a part payment on account of the amount due to the instrument, or promises to pay the amount due thereon in whole or in part, or otherwise waives his right to take advantage of any default in presentment for the payment. Let's say the maturity date is over. Maturity date is over. Now, after the date is over, now the person who has to make the payment, he is saying, he is saying that don't worry, I will make the payment. I promise to make the payment. Okay? Or what he is saying is maturity date is over, no worries. Do one thing. I have to pay 1 lakh rupees to you, no? You take 50,000 today, 50,000 rupees next month. Correct? Or last point. Or he says that देखिए, although the maturity date is over, now you are not eligible to claim the money, and I have the right to stop you from the payment, but I'm not doing so. I know I have to make the payment to you. I will make it to you. I'm a good person. So in that case, if you don't present the instrument, still you will get the payment. Don't worry. Maturity date is over. Today was the maturity date. It is over. Correct? Then you didn't presented the instrument. When you go to the person tomorrow, technically he is not at the point to make the payment to you. Correct? He should make the payment at the maturity date. But still what he is doing, he is being nice with you. He is saying 1 lakh rupees ka payment tha na, 50,000 today, 50,000 tomorrow you can take. I will make the payment to you, don't worry at all. No need to get into the legal troubles. I will make the payment to you. Okay. Second he says that today I don't have the payment, but I promise to pay you the amount tomorrow. You come tomorrow, I will make the payment to you. Right? You will get the payment. Or if he is saying that although I can claim, I can go to court and stop you from taking the payment because you have already exceeded the deadline of taking the payment, but I am not doing it. I am not doing it. I will make the payment to you. Don't worry at all. In all these cases, without presenting the instrument, you can still get the money after the maturity date also. Are we clear? Yes or no? Sure? As against the drawer, if the drawer could not suffer damage from the want of such presentment. Anybody can you understand this one and just tell me? As against the drawer, if the drawer could not suffer damage from the want of such presentment. It is something you've already studied, so I think you can guess it.
सर उसने कह दिया कि तुम प्रेजेंट मत करो, मैं तुमसे कोई डैमेज क्लेम नहीं करूँ.
It is simply like, now drawer says if a drawer could not suffer damage from the want of such presentment, he is saying that don't present the instrument, I will make the payment to you, right? It's like he is requesting now, don't go for the legal process, you will receive the payment. If you go with the legal process, there will be a damage to me. I have to pay the fine, penalty, whatever it is. So it is a request from the drawer that please don't go against me. I cannot bear the damages. I will make the payment to you like that only. So he is asking to waive off the right of damage. Okay? Are you clear? Yes, you have to understand the legal language also. ऐसा नहीं कि I am reading the language and I am explaining it to you and bye bye data see you la 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 la, वो नहीं होगा. Liability of banker for negligently dealing with the bill presented for payment, a very important case. Sometimes what happens, the check is presented and the banker dishonors the check negligently. It means it is like the dishonor is not valid. The reason for dishonor is not valid. Now what will happen? When a bill of exchange accepted payable at a specified bank has been duly presented there for payment and dishonored, if the banker so negligently or improperly keeps, deals with or delivers back such bill as to cause loss to the holder, he must compensate the holder for such loss. Means the check has been presented, and because of the negligency of banker, the check was dishonored by mistake, right? In that case, whatever loss has been suffered by the account holder, right? In that case, the banker has to compensate the account holder or the person who has suffered the loss for such loss. Are you clear? If because of banker the dishonor was done by mistake, then whatever losses you have suffered, direct loss, not indirect loss, whatever direct losses you have suffered, you can claim it from the banker. Banker is under a duty to pay it to you. Okay? Let us say indemnification. The bank has to indemnify you.
This case also that 138 was applied.
10 times I told you 138 will apply only in case of insufficiency of funds. Yes? Rules of compensation. The compensation payable in case of dishonor of promissory note, bill of exchange or check by any party liable to the holder or any endorsee shall be determined by the following rules. Remember law of land? Law of land yaad hai? Guys, yes or no? Remember that part please. It says the holder is entitled to the amount due upon the instrument together with the expenses properly incurred in presenting, noting and protesting it. If the instrument is dishonored, beta, what will happen? In that case, you will go to the court, you will spend some money to notify to the court to advocate fees, this and that karke. So when you will recover the money from the other person, no, the other person will not only pay you the amount of the instrument, but also the amount you have spent on presenting the instrument, noting the instrument and protesting it. Protesting basically means what? When you go to the court of law, whatever charge, whatever stamp paper duty they will ask you to pay, affidavits they will ask you to submit. So all these things are covered under protesting. Are you clear? So those expenses also you can recover. Direct losses. When the person charged resides at a place different from that at which the instrument was payable, the holder is entitled to receive the sum at the current rate of exchange between the two places. India and let's say US. Getting a point? The person is at US, payable at, the bill is payable in the US and the same is dishonored. In that case, whenever he is making the payment, so whatever amount of the bill will be, that will be paid plus expenses will be paid according to the exchange rate of that time on which the expenses are paid. So for example, today the dollar is 1:80, as in $1 equals to 80 rupees, right? The amount is dishonored, the bill is dishonored, right? And the payment by the person is paid, the compensation is being paid after 1 month. And after 1 month, the exchange rate is 1:90. That is $1 equals to 90 rupees. So this person cannot say that at that time $1 was 80 rupees. I will make you the payment accordingly. No, no, no. The payment will be made according to the current exchange rate. Are you clear? This delay happened because of you, and you have to bear the loss. Current rate पे जाएगा, right? उसका फायदा है. But who can predict that the current rate will be less or more than the exact exchange rate? वो predict नहीं कर सकते. An endorser who, being liable, has paid the amount due to on the same is entitled to the amount or so paid with the interest of 18% per annum from the date of payment until the tender or realization thereof, together with all expenses caused by the dishonor and the payment. It is saying that when the amount is being claimed, if there is a delay of 1 month, for example, so what you can claim damages क्या होगा आपका? That amount plus interest on that amount at 18% per annum, plus all the direct expenses. You remember Sale of Goods Act? Unpaid seller can claim price from the buyer, not only price but also interest on that price. Yes or no? वही है, same thing. Are you clear? हाँ, रेट मेंशन नहीं था यहाँ पे, रेट मेंशन है 18%. वो जनरली बैंक रेट पे जाता है, उस वाले पे बैंक रेट पे काम होता है जनरली. 6.25, 6%, 6.75 ऐसे जाता है. बैंक रेट तो आई बिलीव यू अंडरस्टैंड, राइट? पता है ना? बता ना।
इंटरेस्ट रेट
बैंक रेट क्या होता है? बैंक रेट क्या होता है?
बैंक रेट
2 मिनट रुको, 2 पॉइंट रह गए, आ रहा हूँ आपके पास. When the person charged and such endorser resides at different place, the endorser is entitled to receive a sum at the current. This is same thing, right? Wherever the payment is moving, if the one person is in India, the other person is abroad, so the payment will be made in the current exchange rate, not at the exchange rate when the bill was made. Same thing, right? Last point says the party entitled to compensation may draw a bill upon the party liable to compensate him payable at sight or on demand for the amount due to him together with all the expenses properly incurred by him. Such bill must be accompanied by the instrument dishonored and the protest thereof, if any. If such bill is dishonored, the party dishonored in the same is liable to make the compensation therefore thereof in the same manner as the case is the of the original bill. सुनिए ध्यान से. Today I made a instrument for you. Maturity date was after 1 month. On maturity date, the bill got dishonored. 1 lakh का amount was there, okay, and director expenses this and that करके total you have spent, let's say 10,000 on claiming that amount from me. I went to the court of law and I'm standing before the judge. I'm saying, so total amount is 1.1 lakh. I do understand that, right? I will make one more bill for him. Please ask him to bear with me, and whatever maturity date I'm putting on the new bill, that is 1 lakh plus the expenses, I will make the total payment on that date. Okay, 1.1 lakh ka new bill I have given to you, and the maturity date is after 2 months. After 2 months, if again that dishonors, in that case the interest charge, the expenses charge, in that case the principal amount, before it was 1 lakh rupees was the principal amount plus expenses, yes or no? New bill ka what is the principal amount? 1.1 lakhs. So if new will be dishonored again, if the new bill gets dishonored once again, in that case principal amount will be considered as 1.1 lakh plus we will charge expenses on 1.1 lakh, not 1 lakh. Interest will be calculated on new amount 1.1 lakh but not 1 lakh. Okay, so that is what they are writing here. Are you clear with the things? Sure. Ambiguous instrument, it says, देखिए ambiguous instrument means where there is a confusion. I mean an instrument has been made and you're not able to identify that what type of instrument it is. It's a bill of exchange or a promissory note. It means the way you are making that instrument, that way is confusing. Getting a point? Sir, if the instrument is actually ambiguous, then what is the solution for that instrument? Solution is very simple. Whoever has made it, ask him. This instrument is of like which type of instrument this is? This bill of exchange or promissory note? If he says it is a bill of exchange, treat it as a bill of exchange. If he says promissory note, treat it as a promissory note and go ahead. Getting a point?
Yes, sir.
One more thing. If he says that maker says it is a bill of exchange, then the nature of this instrument will be fixed at bill of exchange only. It will not become promissory note again. If he says promissory note, it will be fixed at promissory note. It cannot be changed to bill of exchange. Getting it? So, you're trying to interpret it. Interpret means you're trying to understand the intention of it. With what intention it is made? It is made with an intent of bill of exchange, or it is made with an intent of promissory note. Okay, so when you say ambiguous instrument, what is ambiguous? Ambiguous means confusing. What is confusing here? The intention of making that instrument is confusing. We are not able to recognize whether the instrument which is made in a way, it is made in a way of bill of exchange or it is made in a way of promissory note. That is what we call ambiguous instrument. Are you clear? Read it. Same thing you will see here. Read it once. Any doubts you can ask me. Go ahead. Once you're done with the first para, just let me know once you're done with this para. Done? Up here, you might understand one more thing. As I told you, it is a vague instrument. It is a confusing instrument. So sometimes what happens, the person who is holding that instrument, he only communicates the maker that I am treating it as bill of exchange or I am treating it as promissory note. Once this consensus is built, then the nature of the instrument again will be locked. It will be treated as a bill of exchange or it will be treated as a promissory note. It means it is about fixing the, or it is about arriving at consensus ad idem. Contract act, meeting of minds. So when our minds are not meeting, right, in that case, either maker can make it clear or holder can make it clear that okay, this is the situation, and the whatever things they discuss, that thing will get fixed. Okay? Sorry? Correct. आप communicate करिए, things will be over. Go ahead with the language once. Any doubts, please ask me. Both are satisfied. Satisfaction की बात नहीं. Satisfaction is about the communication. Holder. Sir, देखिए सुनिए. It is not about satisfaction. It is about communication. Again, I would say, I am not satisfying you that it is bill of exchange or it is promissory note. I am telling you it is a bill of exchange because I have made it. Correct? Or second way could be, you are telling me I am treating it as bill of exchange. I am okay. You are telling me that you are treating it as a promissory note. I am okay. It is about meeting of minds, not satisfaction. Okay? It's done.